Good afternoon. Welcome to our monthly teleconference, sponsored by Eric Pelton and Associates PLLC. I'm Mark Donahue. I'm attorney at Pelton Associates, and with me today,
I'm Mike Mulmer. I'm a law clerk here at the firm.
Yep. And we are talking today about the proper use of trademarks. First, this call is being recorded and will be posted online, and we'll be taking questions after the presentation for anyone who's on the line. And also need to note before we get started that this call is not for the purpose of legal advice. We're giving some general pointers about trademark law and how best to use your trademarks and protect your trademarks. But if you have a particular trademark issue, it's an important thing to discuss it with a trademark attorney because specific facts and specific cases matter a lot. And our general observations today may not apply to your case in particular. So, proper trademark use is our topic today, and a lot of people don't realize that there are improper and proper ways to use your trademarks. So the purpose of trademark law is to help consumers figure out, whose goods come from, what source, and if they liked some goods, trademarks help consumers find those goods again, and they prevent consumers from being confused about whether or not the goods they liked are, come from the same people or come from somebody else. So it's important as a trademark owner or as a business owner to brand your products so that your consumers can find you again. If you're putting good products out there, you want your consumers to be able to distinguish you, and you want to make it clear to consumers how they can find your goods in comparison to others. And so you need to make it clear what those marks are that distinguish you from others in all of your advertising and on your products. It's also important to make it clear to your competitors, what features of your marketing are specific to you and distinguish you and are not available to others to put on their products. So we will toss it over to Mike for the first issue here that we're going to discuss, and that's giving proper notice when you're using your trademarks.
Okay. Giving proper notice. What you need to do is to let your consumers and your competitors, I guess, know, like Mark said, what exactly is protected and what exactly you're claiming rights in. So you do that by using one of the proper symbols to denote what your trademark is. If you have a registered trademark, I'm sure you've all seen the R in the circle. You typically put it right after the mark, and that denotes that you have a registration in that mark. If you're claiming rights in the mark, but you haven't yet gotten a registration, and it's a mark for goods, you would use the TM symbol trademark. If it's for services, you'd use the SM for service mark. Now, that's even if you're in the process of applying for a registration and it's pending, you still cannot use the R mark, the circle R mark. You have to use the TM or the SM. And it's important also to use, when you are using the registered trademark symbol, it's important to only use it for the goods or services for which you actually have a registration. You can't go off and use it for, if you start going into another market or doing something else, you can't use it on those symbols properly.
Until you have a registration.
Yeah.
Now joining.
Another thing is when you're presenting your mark to the public is to make sure that the mark itself is distinguishable from material that's around it, other words, other symbols, that sort of thing. So do things to make it stand out. Use bold, italics, different font, that sort of thing, because it loses its distinctiveness and effectiveness when you can't tell where the mark ends, where something else begins.
Yeah, if it's just embedded in a sentence, say in your marketing, it may not be clear to somebody, whether you're using it to describe your product or whether you're actually using it to point out, how your product's different from others, in terms of brand. So that's a pretty, important thing. In addition to that is consistency of use. Oftentimes, when brand owners, vary how they present their mark, it isn't clear all the time to consumers and competitors what is and is not the mark. So for example, if sometimes you present your mark in plural and other times in singular, or you put, if it's also the name of your company, if you present your brand as Mark's Widgets, in one circumstance, and Mark's Widgets Inc. in another circumstance, it's people don't know what to look for necessarily, and it weakens your overall strength. You make your mark the strongest when you present a very consistent and also clear picture of what it is that you claim as a brand. And so you do that with that proper notice symbol, with making the mark stand out, and with always doing those things the same every time. Another issue is over time, a lot of brands evolve and change. For example, Pepsi rolls out a new logo, every several years, and it's important to keep track of how your mark, as you're using it, compares to, say, your trademark registrations, because sometimes those changes will be enough of a deviation to result in not having federal protection. If you've applied for a trademark 10 years ago, it might be important to either file for an amendment to update the mark if it's not a very big change, and that way you can preserve the priority date of your registration, or you need to be supplementing your protection with new applications for new registrations to cover your new mark. And another issue that we see a lot is where you have a mark owner who will use only some of their mark, some of the time. Maybe they've registered it for a logo and then words underneath, and then they find that, well, consumers are still distinguishing them without the words. They start using the logo alone, or with the words alone. It's important to have registrations that match up, with your uses, and because those registrations are powerful, they give you a lot of protection. In making it clear to competitors, what's yours. They create an asset for your business, and they also make it easier to stop infringers, but only if it's matching what you're actually doing. Another pitfall that Mike is going to talk about is being sure not to use your mark in a generic way.
Yeah, I mean, what you want to do is avoid people or yourself or other people using the mark as a general name for a broad category of goods. I mean, because once that happens, the value as a brand, as a mark, is effectively weakened. And I mean, some examples of this in the past: Escalator, Kleenex, Xerox. I mean, some companies have done a better job than others of making sure that it's not, or trying to prevent it from being used generically. But Escalator is an example of a term that was a mark originally, a trademark for what we know as an escalator, and they didn't protect it well, and they used it generically, and other people used it generically, and it got to the point where they have no rights in that anymore.
I mean, what we mean by generically, of course, is that no matter who makes an escalator, we all refer to it as an escalator now. But there was a point when only one company could use that term, and they lost those rights. And Kleenex, a tissue is only a Kleenex if it's made by the Kleenex Corporation, and no other tissue can call itself a Kleenex.
Yeah, and Kleenex is a good example, because Kleenex, if you look at their products, they always say Kleenex brand tissues afterwards. And that's another tip we were going to kind of touch on, was saying that ideally you want to try to use your mark as an adjective rather than a noun or a verb. And such as Kleenex brand tissues, Poland Spring. If you look at it after the mark, it says brand in small letters. Payless says shoe stores in small letters afterwards. So that you're using it as a generic. I mean, not using it as a generic term, using it as an adjective to make it clear what your brand is and what the goods are, and they're not the same thing. They're not they're not one and the same. And along the same lines, you want to avoid using the mark as a verb. I mean, and there's a lot of things that have kind of crept up lately. Googling, rollerblading, Xeroxing, these are all things that we hear. on a regular basis that are trademarks.
Yeah, and if you let that go unchecked as a brand owner, it you fall into the danger of your brand becoming a common term that anyone can use to refer to Xeroxing to make copies on a machine made by someone other than Xerox, or Googling to do a search on a search engine other than Google. Bing, for example, or is Alta Vista still around? I don't know. Okay. But anyway.
And along the same along the same lines as something like escalator. Like when they came up with the escalator, they were the first persons to come up with that invention. It was a new device. There was no generic name for it.
They had a patent, so no one else could make them.
So if you have something that's a new product and there is no generic name for it, come up with a generic name for it. And one good example, recent example that we came up with was Starbucks Via, the instant coffee sold by Starbucks now, always says Starbucks Via Ready Brew on the packaging. So they created that term Ready Brew as the generic name, and Starbucks Via is the trademark.
Yeah, so presumably you could go make your own brand of Ready Brew,
yeah.
Mike's Ready Brew, and Starbucks wouldn't mind. But yeah, Starbucks has created this term to make it safe for their Via. They'll have strong rights in Via if they keep that up.
And so what you want to do is you want to look out for generic uses of the term. I mean, not just in an infringing sense, but I mean, for example, there are signs all over the country. I mean, municipalities put up signs saying no rollerblading. And that's a generic use of a trademark term. I mean, things like that you need to look out for. You need to be writing letters to these people, and you're trying to get that kind of use minimized. And
at least get them to acknowledge the fact that you have a trademark. If you are have the trademark for rollerblade, you need to be encouraging people to use the non-generic term inline skates, so you'll see a lot of dictionary definitions that, like Motown, for example, is a good one. You look up Motown in the dictionary, and it says another term for Detroit, Michigan, and it also says is a trademark of Motown Records, and so anyway, those are good strategies. But so, in conclusion, it's good to keep these things in mind to keep your protection of your brand, to keep your brand strong and make it easy to protect. You don't want to be investing in your mark over many years and eventually find that you don't have exclusive rights to it anymore, and that investment will be gone. And so it's good to think about, when you're selecting a brand, how are you going to use it? You don't pick a brand that from the outset that you're tempted to use as a verb, or that you're tempted to use generically. If, like Mike said, if you need to create a generic term to go along with it, do that from the outset, so people know what they can call competitors' products. And all this requires really getting your legal people, your people who know the proper and improper uses, and getting them together with your marketing people and whoever's putting together your advertisements, making sure that that mark is being presented in a consistent way, in a proper way, and establish a policy that is clear and everyone in the company understands, and can, in that way you can present a united front to your customers and your competitors. So in conclusion, I mean, thank you for visiting and listening in. We do this every month, and in the meantime, you can contact us through info@ericpelton.com. Again, that's info at erikpelton.com. We're also on Facebook and Twitter. We've got ipelton.wordpress.com is our blog, and we're online. It's pretty easy to find us. And again, this has not been legal advice. If you have a specific issue, we advise you to contact a trademark attorney. And finally, this presentation is copyrighted for Eric M. Pelton Associates PLLC, 2011. And thank you for joining us. And we'll